what about if the receiver of the property is the other spouse? So this comment is about a ladybird deed, and you have an owner of a ladybird deed, or owner of the property in the ladybird deed, and then that owner of the property, when they pass away, they're going to list one or more beneficiaries. It's called a remainderment on the ladybird deed, so that that person can automatically inherit or receive the property without going through a probate process. So that's why we're calling this person the receiver. They're receiving the property after the original owner of the property passes away. So I did a video on once someone inherits the property, like your children or a friend or another relative, then the property does end up getting reassessed for property tax purposes. Once the new owner, once the documents are updated and the new owner takes control, once they know that the original owner has died and the remainderment of the beneficiary now owns it, that's what triggers this reassessment for property tax purposes. And if the new owner, the receiver of the property, is planning on living in the property, then of course, if you're here in Florida, they can apply for their own homestead tax exemption to get that property tax cut, so they don't have to pay as much in property taxes, but it's most likely still going to be higher than the original owner was paying because it's going to be based off of that newly assessed value. And since property values have gone up, in some cases very drastically, throughout Florida, you would normally be looking at some type of property tax increase, unless we are talking about a spouse. So the spouse is essentially the only person who does get to benefit off of the homestead exemption of the other spouse. So if you are legally married and you're living in the property with your spouse, then you're both entitled to that same homestead exemption, and it doesn't typically change when one spouse dies, because the other spouse does get their spouse's homestead exemption. Now, what we see more often in this scenario is if it's a married couple but only one of their names is on the deed, then we'll often add the other spouse to the deed. They have to join in on the deed anyway. There's no way around that in Florida because of the constitutional protections of homestead property. So oftentimes, rather than making a spouse a remainderment, we'll actually have the spouse who's not on the deed be added as what's called the life estate grantee, or the other person who's going to be living in the property throughout the rest of their life, because the way it works is you can't kick someone out of their homestead property anyway. However, it is possible, and there might be a reason that you don't want to do it that way, and you might want to leave your spouse as a primary beneficiary and somebody else as a contingent beneficiary through a ladybird deed, in which case your spouse does, is the one individual that has the luxury of continuing to pay at the same homestead rate as, when you were both living in the property, because you can share that tax exemption together as a married couple living in the same property together. However, that's not the case for children or other relatives or other friends. So when property is inherited by your children or someone else, there is going to be that reassessment, and there will be new property taxes. So I hope this answers the question. If you have any other questions about ladybird deeds or probate or estate planning or asset protection, Medicaid, and you're in Florida, please don't hesitate to contact our office. We are atCause Law Office, the non-stuffy attorneys, and the link is in my bio.